This Honorable Court of Appeals of Tennessee is now in session.
Thank you. On behalf of Judge Frierson and Judge McBrayer, welcome. This will be conducted the same way that it would be conducted if we were all in the Nashville courtroom. So let's begin. Ms. Dempsey, would you please call the case?
David Jernigan versus Robert Evan Paasche et al.
Good afternoon. May it please the court, I'm Joe Bednar, Sr. of the Nashville Bar. Along with my son, we represent the appellant. We also represented the plaintiffs in the trial court. We have raised 4 distinct issues on this appeal, but they are all related to the CT scan that was performed at Cookeville Regional Hospital. I believe that it will help the court if I bring some important facts to the court's attention in order to show just how we were prejudiced by the errors committed by the trial judge. In August of 2012, Mrs. Jernigan was 53 years old when she presented to the emergency room at Cookeville. She showed up complaining of pain in her abdomen 9 out of 10, as documented by the triage nurse. She had a prior hernia surgery. While she was in the emergency room, she vomited. Dr. Paasche ordered a CT scan, very appropriate, that was read by the radiologist. The radiologist excluded all pathology except a large paraesophageal hernia. Dr. Paasche got that report and he did no further investigation. He spent a couple minutes with the patient, made a diagnosis of reflux. She still had pain 8 out of 10, but she was discharged. As soon as she left, she started vomiting again and continued to vomit for the next 21 hours. She didn't want to go back to Cookeville because she felt she hadn't been treated properly. So she went to Crossville. When she showed up at Crossville, she complained of the same symptoms: abdominal pain, vomiting for the last 21 hours, too numerous to count, as documented by the triage nurse. They put her on what is called the fast track. She was under a nurse practitioner while she was there. When the nurse practitioner was getting off duty at midnight, she went in to see Dr. Wojcik and told him that she was not comfortable with sending this, to quote her, this little lady home, and asked Dr. Wojcik to see her. Dr. Wojcik states that he did go in and see her, spent a minute and a half with her and discharged her. Family members were with her the entire time, and they have testified that the doctor never came in to see the patient. The plaintiff's expert proof in the first trial and what we would have submitted at the second trial if we had been allowed to was that the CT scan showed that she had 2/3 of her stomach up in her chest cavity. This was the paraesophageal hernia. 2/3 of her stomach upside down in the chest, and it was twisting, causing an obstruction, and they called it a volvulus. This obstruction was preventing food and drink and even secretions to get down into her intestine, and it was causing this pain and the vomiting. They also testified that this large paraesophageal hernia was a dangerous condition and it needed to be addressed by a general surgeon. The defense, on the other hand, took the position that a hernia is a hernia is a hernia. The only time you need to be concerned is if there's a volvulus or an obstruction. And if there was one, the radiologist surely would have called it. The report doesn't mention it, therefore there is none. They also had a radiologist that stated He read the CT and there is no volvulus. So I think you can see how important the CT scan was. Both sides were relying on the CT scan. This was the point of contention. Experts on both sides were using it. The case was tried in December 2017 in front of Judge Amy Hollers, and it resulted in a defense verdict. Judge Hollers granted the plaintiff a new trial as 13th juror, stating that the evidence preponderated in favor of the plaintiff. She also, as a separate grounds for the new trial, she stressed the improper arguments by defense counsel in closing and stated they were bad enough that was grounds for a new trial. She also, in her order, took a great deal of time to detail the blame shifting that had occurred at the first trial. The case was reassigned to Judge Young. And in August of 2019, the defense filed numerous motions to exclude our radiologists, to exclude our general surgeons, and also accused the plaintiff of trying to complicate this case by disagreeing with the findings of Dr. Martinez and the CT report. We were also accused of blame shifting, as if a plaintiff can blame shift. The judge actually granted a motion to keep us from blame shifting, and at the same time, he issued an order that prohibited any expert testimony of any kind to add to or contradict that CT report. In other words, the CT report was now gospel. We couldn't contradict it. We couldn't argue with it. It was it. Judge, this is tantamount to the judge granting a partial summary judgment. He invaded the province of the jury. He just determined that CT was the truth and the whole truth, and nobody could contradict it. That was improper. We went back for a second pretrial conference, and the judge on his own bifurcated the trial. He just announced that he was going to bifurcate the trial. Enix versus Clay holds that bifurcation in some circumstances is appropriate. But they say a case should only be bifurcated when the issue to be tried is so distinct and separable from the others that a trial of it alone can be had without an injustice. The plaintiff suffered an injustice because med-mal cases can't be bifurcated. They're not suitable for bifurcation because you can't separate standard of care from causation issues. When the doctor performs a differential diagnosis, he's actually looking at the cause of each potential problem that could exist. Causation and standard of care are inseparable in most medical malpractice cases. We need experts to educate the jury. In Enix, the Supreme Court also noted that bifurcation should occur in, I quote, only the most exceptional cases and upon a strong showing of necessity. In this case, there was never a showing of necessity, and there was no necessity. Comparative fault occurs, it's with us, and we see it in almost every case. Judges handle comparative fault and blame shifting with the rules of evidence. The problem that was presented to the judge can be solved by just enforcing the rules of evidence, 401 and 403. The evidence is either relevant or not, and it's either prejudicial or it's not. So bifurcation was unnecessary. The third thing he did on the next conference was disqualify or not disqualify. He just would not allow us to bring in our other experts. And I think it was only because they weren't ER doctors. I'm running out of time, so I'm going to reserve the remaining 3 minutes. Thank you.
Well, you'll have your 3 minutes for rebuttal. Now it's time for the appellees. I understand you will be bifurcating your time.
Yes, sir. May it please the court. My name is Danny Rader, and I represent Dr. Paasche in the case. And then, of course, following me will be Mr. Llewellyn, who represents Dr. Wojcik. They really are two separate cases, but we tried them together. I guess I want to start with the abuse of discretion standard. All of the issues presented before the court today are subject to the abuse of discretion standard. And as the Supreme Court said in the 2020 Harmon case that I cited in my brief, if reasonable minds can differ as to the propriety of the trial judge's decision, then the decision should be affirmed. And that's really true as to every question that's presented to you today. Of course, the first issue is the bifurcation and whether or not the bifurcation was proper. The Enix court said back in the 80s, when bifurcation was first permitted in Tennessee, that the court should consider the possibility of juror confusion, risk of prejudice to the parties, and the need for judicial efficiency. Here, the issue, and Mr. Bednarz takes issue with my characterization of it, but this was multiple trials within a trial. Mr. Bednarz talked to you today in direct argument about the CT scan and what the CT scan he claims would have shown. All of the experts who testified on behalf of the plaintiff and the defendants in the case testified that the ER doctors are not expected to read radiology scans. I know in the CSI world, we expect our doctors to look at the scans and interpret them, but they're not qualified to do so. In fact, Dr. Paasche's testimony, he is not even credentialed to do so at the Cookeville Hospital. He would not be permitted to do that even if he wanted to do it. Plaintiff's principal expert, Dr. Bruce Jernigan, who's an emergency room physician and professor from the Medical College of Georgia, he testified he practiced for 47 years. He says he's never been trained to read CT scans, and he doesn't read CT scans. So when we're judging these physicians, and the jury's asked to judge these physicians, they're asked to judge what the physicians knew in the time, not what they might have imagined through hindsight or through some skill that they didn't have. It's what did they know at the time? And what they knew at the time was what was in the CT report. Now, with respect to blame shifting, my client has never asserted that the CT report was anything other than correct. Never asserted that the doctor, the radiologist, Dr. Montanez, reading the CT was anything but correct. We haven't blamed him or asserted fault against him in any fashion, either directly or indirectly. No implication of fault. We believe the CT report was correct. All of the evidence that we presented in the first trial was that the CT report was correct. The only person who has blamed Dr. Montanez or accused the CT report of being anything other than completely correct is the plaintiff. And of course, they tell you that they say the stomach was upside down, it had a volvulus or a twist, and had an obstruction. But none of that was known to the ER doctor. And so the plaintiff's experts testified in this second trial that what you're supposed to do is look at the CT report. It says a paraesophageal hernia. That's not an emergency finding. People have those all the time. And the plaintiff said that they should clinically correlate. Their experts did a good job of trying to explain that theory to the jury. One of their experts, Dr. Lunders, used a balloon showing the stomach and twisting it to show how they described that to happen. So the plaintiff got to present all the proof that they wanted to present on this issue, even at the second trial.
Excuse me for interrupting. As I understand, this jury trial was conducted on the sole issue of standard of care. Is that correct?
The first phase was, and so it didn't get to the second phase that would have addressed the causation and whether or not the failure to obtain a surgical consult, which was their alleged breach of the standard of care, whether or not that caused any injury to Mrs. Jernigan, which because of the volvulus. All of those kinds of things would have come in the second phase of the trial had the jury determined there was a breach.
Have you referenced any cases where the issues of standard of care and causation have been bifurcated in med-mal cases?
No, sir, we've not located one, but we've also not located any case where anyone asked for a bifurcation and it was denied. It simply was a novel attempt to solve a difficult problem. You know,
Your client's position then is that those two issues are distinct and separable?
They are, Your Honor, and it's important that they stay distinct and separable. They're separable for two reasons. Number one, the statute separates them. They're separate sections of the healthcare liability statute. Number two, it was necessary to separate them because of this trial within a trial strategy. And Mr. Bednar said to the trial court, he calls it the second malpractice allegation. It's in volume 9, page 28. The second malpractice allegation comes in. I don't see how any doctor, any surgeon can say, I would have come in and examined her and done the same thing. And Mr. Bednar says, and what our experts then said is that the standard of care would have required these surgeons, the supposed consulting surgeons, to come in, put their hands on the belly, look at the CT film, and then they would have seen on the film that she had a blockage over reading the radiologist. So it was plaintiff's attempt to try the second malpractice allegation, his words, not mine. And it was essential to separate those because otherwise you do have a confusion for the jury. Plaintiff characterized what the surgeon would have done in terms of the standard of care, what the radiologist is supposed to put in the report in terms of the standard of care. And no jury could possibly keep those things separate and complete if the issues are not separated in that regard. So
and
what
the radiologist here was never named as a party.
He was never named as a party, and the record's silent on why that happened. But I submit to you that by the time the plaintiff disclosed an expert who criticized the radiologist, and he did directly assert that he missed it in his offer of proof. By the time that happened, the statute of repose had run against the radiologist. So we'd submit to the court that the whole plaintiff's strategy at trial was to try to paint the emergency room doctors who were defendants with some error that they perceived, that the plaintiff perceived, not the defendant, but the plaintiff perceived on the part of the radiologist. That's why they're talking to you about the CT scan and what they say it actually showed. The ER doctor had no way to know that or any expectation to know that. I'm just running out of time, so I want to jump quickly to the exclusion of the experts. The experts were not excluded because of their specialty. They were excluded because they testified that they didn't know the standard of care. And the plaintiff had two experts who did testify that they did know the standard of care and knew the standard of care. The plaintiff's counsel admitted that they were not necessary. The surgeons were not necessary to offer proof in that standard of care phase. Of course, they did that before they realized the case was going to be bifurcated. And after they realized the case was going to be bifurcated and they would be unable to confuse the jury by submitting all of that unrelated evidence, that they tried to walk that back. And finally, I'm 10 seconds, but I want to say that the plaintiff didn't object during the trial to any of the things that they're really criticizing here. And the trial judge noted it. When they came to the end of the trial, he said, you didn't object to any of those things. And so I can't rule and I can't help you.
Okay, thank you, Mr. Rader.
Thank you, Judge.
Mr. Llewellyn.
Thank you, Your Honors. My name is Grant Llewellyn of the Knox County Bar, and I had the pleasure of representing appellee and defendant James Wojcik, MD, both through both trials and in the appellate phase. First of all, I will say that this was one of those exceptional cases that warranted bifurcation. And I think just a brief understanding of the history of the case and how we get through the first trial and how we get to the second trial clearly shows that Judge Young exercised his discretion appropriately and came up with the best solution possible to deal with a difficult situation, and in that situation and why standard of care and causation are completely separate issues in this case is because the entire basis for plaintiff's causation proof at trial, at the first trial and would have been at the second trial, is based on ominous emergent findings that their experts say was present on the CT scan that was not present on the report dictated by the reviewing radiologist, Dr. Montanez, and by clear implication was not information available to the defendant physicians when they cared for and treated Mrs. Jernigan. So that creates
Excuse me for interrupting, counsel. Was there a strong showing of necessity for bifurcation in this case?
I think the history of the case and what occurred in the first trial with the radiology issues, and when dealing with pretrial issues in the second trial, and plaintiffs' repeated insistence that they needed radiology findings outside of the report to prove only causation, It's strictly for causation. It has no bearing on standard of care. I think that shows the necessity, coupled with the understanding that it creates such a mess for the jury to try to parse out, and a mess evidentiary wise, in having repeated testimony of volvulus and obstruction and emergency findings on a CT that's independently reviewed by experts after the fact, and then a CT report that says no acute intra-abdominal or pelvic pathology otherwise, and no bowel obstruction, and the only thing listed is a large paraesophageal hernia with no other acute or emergent findings. So you go down this rabbit hole, which was evident by the first trial, and if the court would refer back to Dr. Ola Zagasti, plaintiff's radiologist, his trial testimony from the first trial was made an offer of proof and is attached in the exhibits in volume 2, I believe, of the trial exhibits. There were numerous side conferences, jury out, objections dealing with his radiology testimony and what could or could not be presented to the jury, and what response and what questions could or couldn't be asked based on radiology findings, again, that aren't contained in this report, which is what all experts agreed, that the defendants had a right to rely on the report, that they don't have a duty to independently review the CT because they're ER doctors, they're not radiologists, and that the issue comes down to, based on what's on the report and the patient's clinical condition, what does the clinical correlation of that require in accordance with the standard of care? So plaintiff says it requires consulting a general surgeon. Defendants say it doesn't require that. The patient doesn't have any acute problem. They can be discharged home. So I think there is a strong showing of necessity that the trial court recognized by looking back at the procedural posture of the case.
Thank you.
So, and I think it's telling in appellant's reply brief on page 1, where he states, if no emergency or surgical issue, if there's no emergency or surgical issue, how could it possibly be a violation in the standard of care not to get a general surgeon consult? And so plaintiff's whole problem with this case is not the bifurcation or limiting experts to a causation phase as opposed to a standard of care phase. Plaintiff's problem is the facts of the case and the proof of what's contained in the records and the report. And so the problem that Judge Young recognized is the defendants need to be judged, their conduct, their standard of care needs to be determined by the information that all parties agreed was available to them at the time. And that was the CT report. So getting into all this volvulus and obstruction was plaintiff's attempt to change the facts and manufacture a higher standard of care, which plaintiff in the reply brief on page 1 acknowledges. Why should the defendants order a surgical consult if there's no volvulus or no obstruction? And we agree completely. That's why they had to taint the defendants with some emergency condition. That's why they say it's so important to get findings of the volvulus and the obstruction that aren't on the report in front of the jury, so the jury can hear that. And I would so I think by showing of strong necessity, just look at the transcripts from the 3 pretrial conferences leading it, and it just shows that we had 3 pretrial conferences leading up to the second trial. That in and of itself shows the painstaking task that the trial court took to come to this solution, and plaintiffs repeated insistence during those conferences that the radiology and surgical issues are needed strictly for causation. The only reason it's important is for causation. This is separate and distinct from the standard of care. That's on page 69 of volume 8 of the August 12th, 2019 hearing. That's plaintiff's counsel's statement. So the trial court, in trying to fix the concerns from the first trial, coupled with plaintiff's repeated insistence that they have to talk about these issues only for causation. These are distinct from standard of care. The trial court came to the appropriate discretionary decision of let's bifurcate these issues. It's simpler from an expert standpoint. Each party had 2 ER experts. Call them in the standard care phase, save the surgeons and the radiologist for the causation phase. It's simple for the jury to understand. It's simpler to put on experts. It fixed a complex problem.
Thank you.
Thank you, judges.
Mr. Bednars, you have 3 minutes.
Okay, thank you, Your Honor. First of all, in regard to the radiologist, we did not sue Dr. Martinez because we don't think he did anything wrong. We still don't think he did anything wrong. What he read in the CT scan was correct. Our experts did not disagree with what he put in there, but he didn't go far enough. Now, radiology reports, CT reports, they're looking at film. It's not all black and white. You got all these gray areas. You can have a film interpreted differently by different radiologists. Just because they differ on their interpretation does not mean they violate the standard of care. It has to do with skill level. It has to do with experience. We've never, ever tried to put any blame on Dr. Martinez. Conversely, Dr. Wojcik did amend his complaint to alleged negligence against Dr. Martinez, and they couldn't produce an expert to carry it through. We filed a summary judgment and we prevailed and it was dismissed. So they are the ones to try to prove negligence on Dr. Martinez. Now, Dr. Davis, that was excluded, clearly was qualified to talk about the standard of care. And if we had been given a choice, 2 experts, I would have chosen one ER physician and Dr. Davis, who was revealed as a standard of care expert. He was at Emory. He knows more about hiatal hernia.
He was identified as a standard of care expert for an ER doc.
Because he works with ER docs every day in Emory. In other words, he works so closely with the emergency room physicians. He knows what the standard of care is as it applies to the facts of this case. If they wanted to contest that, they could have done it at a 104 hearing, but the statute is pretty clear and the case law is pretty clear. You don't have to be in the same specialty. You just got to have knowledge that would help the jury. We believe he was clearly qualified to testify as to the standard of care. And he had his qualifications were so impeccable. He had unique qualifications. It was clearly error to keep him from testifying. And like I say, if I could only bring 2 people, he'd have been one of the 2. I would, but I was restricted to the ER docs. In regard to, let's see, trying to cover too much in too little time. They say I didn't make a contemporaneous objection. How many times do you have to object? We filed motion after motion after motion, reconsideration after reconsideration. Judge Young was not going to change his mind on any of that, no matter how many times I objected. Your Honor, we respectfully submit we did not get a fair trial the first time. Judge Hollis did the right thing. We did not get a fair trial the second time, and we would ask the court to send it back and give us a chance to get a fair trial in this case.
Thank you very much, Mr. Bednars. Thank you to everyone.
Thank you,
We
judges.
appreciate your participation today and your arguments.
Thank you.
Ms. Dempsey, would you please close us out for this session?
The Honorable Court of Appeals is now in session. In recess
Till 3.
till 3 p.m.
Thank you. Thank you very much.